Morning, ma'am. Can I ask why you're standing out here this early?
Because this is my house. I'm going inside.
I need you to stay right there for a second. Got a call about suspicious activity.
Suspicious?
For being on my own driveway? Let's not make this difficult. Do you have identification on you?
I do.
And you should be very careful how you explain why.
At 6:12 a.m., the street was quiet enough to hear the sprinklers click off. A black sedan idled at the curb. Blue lights stayed dark. A woman in a robe stepped onto her own driveway barefoot, holding a phone, and the question that followed would end one career and begin a sentence that would last 15 years. In America, justice is blind, but that morning, it saw color first. If you believe power reveals character and systems reveal truth, stay with this story, not for outrage, but for understanding. Because what happened on that driveway didn't end with an arrest. It wired institutions, careers, and lives. The patrol car didn't belong on that street at that hour. It moved too slowly, tires whispering over asphalt that had been poured to stay quiet. At 6:12 a.m., the neighborhood was suspended between night and morning, sprinklers ticking off in sequence, porch lights still glowing out of habit. A newspaper folded like an afterthought at the end of a driveway. The officer saw the house before he saw the woman. Large, brick, flagstone steps, federal enclave, technically jurisdiction shared, rules layered, every stop supposed to be justified twice. He rolled past once, then again. Training called it area familiarization. Policy called it discretion. On the radio, a dispatcher mentioned a vague bolo from the night shift, possible casing activity. No description, no vehicle, just a time window that swallowed half the morning. The officer slowed, eyes tracing the property line, the darkened windows. When the front door opened, he straightened in his seat. She stepped out barefoot, wrapped in a robe, phone in her hand. Not furtive, not hurried, just present. The officer parked, body camera activated with a soft chirp. The manual required it before any citizen contact. He adjusted his belt, opened the door, and let authority settle into his shoulders the way he'd been taught at the academy, feet planted, voice neutral, hands visible. Ma'am, he called, measured. Can I ask what you're doing out here? She stopped, looked at him, then at the car. The camera caught the pause, the way she angled the phone slightly outward. I live here, she said, calm, even. And you are? He gave his name, rank, department, procedure. She nodded once. I'm recording, she added, not confrontational, just factual. The law allowed it. He knew that. The policy memo had gone out last year after a settlement. Still, something tightened. He asked for identification. She didn't refuse. She asked why. That was the pivot. The training slide had warned about it. Challenge to authority may escalate encounter. He cited the bolo, the early hour, the need to verify. She listened, eyes steady. There's no reasonable suspicion, she said. I am on my property. Am I being detained? The question landed with weight because it was precise, legal, the kind that doesn't bluff. He hesitated, then answered the way policy allowed when certainty wavered, just trying to figure things out. Silence stretched. A sprinkler head hissed somewhere down the block. She took a step back toward her door. He stepped forward. Ma'am, stay where you are. The words came sharper than he intended. The camera caught the shift. She stopped again. I don't consent to any searches, she said, still calm. If you're detaining me, I'd like to know the basis. He radioed for a supervisor. Standard when an encounter hardened, the dispatcher acknowledged. Time slowed the way it does when both sides realize something is moving without them. She held up her phone now, framing him clearly. For the record, she said, this is my home. He asked for ID again. This time, she handed it over. The name registered a beat later. The camera recorded his eyes dropping, then lifting. A flicker. He didn't react outwardly, but something in the air changed. He took the card to the patrol car, checked it. Federal judge, sitting. Appointed over a decade ago. The kind of name you read in opinions, not on a driver's license at dawn. The supervisor arrived quietly, no lights. A low-voiced exchange by the cruiser. The decision was made in murmurs and glances. Contain, document, justify. When they returned, the supervisor spoke. There's been a misunderstanding, he said. You're free to go. She looked at both of them. I was always free, she replied. As they walked away, the officer began his report. He chose words carefully. Suspicious behavior. Failure to immediately comply. Lines that would later be read aloud, slowly, under oath. The camera kept rolling as the sun finally cleared the rooftops, illuminating a driveway where nothing illegal had happened, and everything had changed. The recognition didn't soften the morning, it sharpened it. By 6:27 a.m., the patrol car was gone, but the encounter stayed behind like heat trapped in concrete. Inside the house, the judge locked the door and leaned her back against it. Phone still in her hand, screen glowing with the video she hadn't watched yet. Her robe felt thin now, exposed. She exhaled once, controlled, the way she had after verdicts that never felt clean. She didn't call the police department. She called her clerk. The line connected on the second ring. "I need you to listen," she said, already moving through the house, barefoot on tile, then wood. "And I need you to write down the time." The clerk heard the steadiness first, then the pause beneath it. Judges didn't panic. They documented. At headquarters, the supervisor filed a preliminary contact log before his coffee cooled. Policy required it for any citizen interaction involving recording, especially within a federal enclave. He chose neutral phrasing, careful verbs. The officer sat across from him, posture rigid, replaying the moment the name hit his screen. Training hadn't prepared him for that, only for threats, for flight, for resistance. Not for power wearing a robe. Internal Affairs was notified automatically when the Bodycam upload flagged a sensitive subject. The system didn't care about intent. It cared about exposure. By mid-morning, the video had been viewed by 3 people who hadn't been there. They watched it without sound first, as protocol suggested, observing posture, distance, escalation cues. The forward step, the command. The pause before recognition. Someone rewound it. Someone frowned. In chambers, the judge sat at her desk and stared at the seal on the wall. She had defended stops like that one, parsed reasonable suspicion down to commas. She knew how this would be argued. She also knew what the camera showed when doctrine failed reality. Her phone buzzed with messages she didn't answer. Ethics rules require distance. Silence was safer. A call came from the chief's office just after noon, apologetic in tone, non-committal in substance. "We're reviewing the matter," he said. "We take these concerns seriously." She thanked him. That was all. Gratitude is not admission. She knew that too. By the afternoon, Legal Affairs had stepped in. They asked for the report draft. The officer had written it already, hands steady, language practiced. He included the bolo, the perceived non-compliance, the rationale for continued engagement. He did not include the moment of recognition. He didn't think of it as a mission. He thought of it as relevance. A lieutenant circled one line with a pen. "This," he said quietly, "needs to hold up." Across town, a journalist received an anonymous tip. Judge stopped outside her home. The message read, "Bodycam exists." It wasn't published. Not yet. But it moved. At 5:48 p.m., Internal Affairs opened a formal inquiry. The notice was procedural, almost gentle. The officer was placed on administrative duty with pay as required. His badge stayed with him. His gun did not. He went home early, uniform folded, trying not to replay the footage he knew others were watching frame by frame. The judge drafted a recusal notice that evening. 1 paragraph, clean, to avoid any appearance of impropriety. The language felt clinical for something that had cut so close. She saved it, unsent. The system was doing what it always did, slowing things down, absorbing shock, redistributing risk. No one raised their voice. No one admitted fault. But decisions were being made in margins and footnotes, shaping a narrative before anyone asked what it meant. The report was finalized just before midnight, and in one line, carefully worded, confidently false, the story began to tilt. The courtroom smelled like old paper and lemon polish, the kind of clean that tries to erase history and only makes it louder. By the time the first hearing began, the story had already split into versions. One clean enough for a report, another too messy to stay buried. Evidence doesn't announce which side it's on. It just waits. The judge entered from a side door this time, not the bench. No robe. No clerk at her shoulder. She sat behind counsel's table, hands folded, posture unchanged. Familiar space. Unfamiliar gravity. The irony wasn't lost on anyone, but no one spoke it aloud. In court, silence is a tool. The prosecution moved first not on bias, not on profiling, but on facts that could be pinned down without philosophy. Falsification of records. Obstruction. Deprivation of rights. Under color of law. Clean statutes. Verifiable elements. The kind that survive appeal. They played the body cam footage at half speed, timestamp blinking in the corner. 6:12:44, the forward step, the command, the pause. A former training officer testified about stop thresholds. Reasonable suspicion requires articulable facts, he said, voice flat, practiced. Not a hunch, not a feeling. He pointed to the bolo. Vague, uncorroborated. Expired. The defense objected. Overruled. The line stayed in. When the officer took the stand, he didn't look at the judge, he looked at the jury. He spoke in the cadence of reports, measured, procedural, stripped of color. "I acted in good faith," he said, "based on my training." The words sounded familiar because they were. They had been used before, sometimes successfully. Cross-examination was quieter, dangerous in its calm. The prosecutor didn't raise his voice. He asked about policy memos, dates, signatures, acknowledgement receipts. The officer confirmed he'd received them. "And this memo," the prosecutor said, holding up a printed page, states that recording by citizens is lawful and not grounds for detention. Correct? A pause. Correct. The false line in the report surfaced slowly, like a bruise. Failure to immediately comply. The video contradicted it, frame by frame. The jury watched compliance happen in real time. The officer's jaw tightened. He didn't argue. He explained. Stress. Perception. The prosecutor nodded, then asked the question that landed hardest. "When did you learn who she was?" The answer came out softer than intended. "When I ran the ID." "And you didn't include that in your report?" "No. Why?" "I didn't think it was relevant." In the gallery, the judge closed her eyes for a second, not in pain, but in recognition. She had ruled on relevance for 15 years. She knew how elastic it could become. The defense tried a different angle. They called an expert on officer decision-making under uncertainty. Slides appeared, stress curves, cognitive load, reaction times. The expert spoke about ambiguity, about how training can narrow perception. It was persuasive. It always was, but the prosecutor waited. On redirect, he asked a single question. "Does training permit you to invent facts?" The expert hesitated. No. The ethics hearing ran parallel, quieter, almost ceremonial. The judge submitted her recusal notice the same day the jury began deliberations. It was accepted without comment. By evening, her resignation followed. Not forced, not voluntary, necessary. The institution needed distance. She provided it. The verdict came back on the third day. Guilty. No gasp. No applause. Just the scrape of chairs and the soft exhale of a system that had chosen clarity over comfort. The officer stared straight ahead, expression trained flat. The judge remained still, absorbing a truth that felt less like vindication and more like loss. Outside, cameras waited. Inside, the court adjourned. Sentencing was scheduled for a later date, and for the first time since dawn on that quiet street, no one pretended this would end cleanly. Sentencing didn't feel like an ending. It felt like a counting. The courtroom was smaller this time. Stripped of spectators, the air heavier for it. Guidelines sat on the bench in neat columns, numbers arranged to look neutral. Enhancements for abuse of authority, for falsification under oath, for civil rights violations committed while armed and on duty. The law spoke in increments, months stacked into years with bureaucratic calm. The officer stood when his name was called. He had been standing a lot lately. Administrative hearings, decertification boards, meetings where no one asked how he was sleeping. His attorney argued mitigation, no prior disciplinary record, commendations, a career built on service. He spoke about intent, about stress, about a moment that had spun beyond control. The words hovered, searching for purchase. The prosecution answered with tape. They didn't replay the stop. They played the report being dismantled, line by line. The falsehood wasn't dramatic, that was the point. It was ordinary, easy. The prosecutor reminded the court of precedent: sentences upheld when officer lied to justify force, to justify stops, to justify outcomes. If the record can't be trusted, he said, the law collapses. The judge, another judge, now listened without expression. When she spoke, it was slow, deliberate. She cited the statute, 18 U.S.C., section 242, willful deprivation of rights under color of law. She acknowledged the weight of incarceration for someone trained to enforce it. Then she said the line that settled the room. Authority is not a shield. It is a responsibility. 15 years. No gasp. Just the quiet recalibration of breath. The officer nodded once, almost imperceptibly. Training again. His family didn't move. Shock arrives later, when the room empties. The former judge watched from the gallery, hands folded. The seal of the court above her head, now ornamental. She didn't feel relief. She felt exhaustion. Justice, when it comes, rarely feels like victory. It feels like something heavy finally set down, and the ache that follows. Outside the courtroom, consequences multiplied. The officer's certification was revoked within the hour. Pension forfeiture followed. automatic under state law for felony conviction tied to duty. Civil suits moved forward clean now, unencumbered by criminal uncertainty. Settlements were discussed in closed rooms with careful language. Departments across the state issued memos that week, revised stop standards, mandatory articulation audits, bodycam retention extended from 90 days to 2 years, bias training restructured, not as a seminar, but as evaluation failures documented, patterns tracked. Oversight boards gained teeth. None of it was named after him. Systems prefer abstraction. The former judge packed her chambers slowly. Books first. Photos last. She donated the robe, kept the gavel. At a law school across town, a visiting professorship opened quietly. Constitutional law, Fourth Amendment, she accepted. Smaller room. Closer faces. Different kind of authority. In a cell miles away, the officer learned the rhythms of a place he'd only seen from the other side. Counts. Lights, silence that stretches. He wrote letters he didn't send. Appeals were discussed, then narrowed. Facts are stubborn that way. The public moved on. Headlines faded, metrics improved, complaints dropped. The system adjusted and called it progress. But late at night, in 2 different rooms, 2 people replayed the same. Morning sprinklers, a robe, a question that had been answered wrong. And both knew that what remained wasn't punishment or reform, it was cost years later. The driveway looked like any other. The concrete had been resealed, the hedges trimmed lower. Morning arrived without ceremony now. No patrol cars drifting past, no cameras humming quietly at a belt. At 6:12 a.m., sprinklers still clicked off in sequence, faithful to a schedule that never learned the weight of that hour. The former judge arrived early to campus, as she always did. The classroom was smaller than her old courtroom, but the acoustics were honest. When she spoke about the Fourth Amendment, she didn't perform it. She traced it. How suspicion hardens, how language stretches, how power mistakes certainty for truth. Students listened differently when she paused. Her silences carried case law without citation. She never showed the video. She didn't need to. Across the state, the officer marked time the way institutions teach you, to counting in units small enough to survive. He worked in the library now, a quiet mercy. He read appellate opinions out of habit, then necessity. In the margins, he wrote questions he didn't have anyone to ask, not about the sentence, about the moment before it all tipped, the step forward, the command, the choice that had felt automatic until it wasn't. Reforms became routine. Dashboards updated quarterly, stops declined, complaints flattened. Oversight reports spoke of measurable improvement. They were right. Systems can learn. They can correct. But they don't remember. The former judge sat on a panel once, years after, discussing accountability. Someone asked if she believed the sentence had been just. She considered the question longer than etiquette required. It was lawful, she said finally. Justice is harder to measure. No one pressed her. Some answers don't open further doors. Letters arrived sometimes, students, clerks, people who had watched the footage late at night and needed to say something to someone. She read them all, responded to a few. Silence, she'd learned, could be generous. On a visiting day thick with noise, the officer watched families reassemble themselves across plastic tables. He didn't look for forgiveness. He looked for understanding. The system had taken his badge, his years, his certainty. It hadn't taken his responsibility. That stayed. When parole hearings came, they were procedural. Risk assessments, compliance records. He spoke once, briefly. Not about stress, not about training. About the lie, how small it had seemed, how large it had become. The board listened without reaction. They marked their forms. Outside, the law continued its work, uneven, imperfect, necessary. The case found its way into training manuals, stripped of names, reduced to lessons. Articulate, verify, de-escalate. The words mattered more now because they had cost something. On that quiet street, nothing marked what had happened. No plaque, no sign. Just a place where authority had been tested and found wanting, and where accountability had arrived, late but undeniable. Justice, in the end, didn't restore what was lost. It rebalanced what remained. And in that balance, uneasy, unfinished, the system learned to look a little longer before it decided what it was seeing.